So let's start with just the idea of a trust. If we set up a trust, basically a revocable living trust, we're saying, I'm going to keep control of all my assets while I'm alive, but I'll have my planning done so if something happens to me, if I become incapacitated or I pass away, everything's in place. There's no need for court involvement. There's no question about what's going to happen. I've already decided. Well, for that to work, the assets that we want to control need to be either owned by the trust or need to be directed to the trust by some kind of an assignment document. So we call that either funding of the trust or aligning the assets with the trust. So in our office, the way we handle that is we say, if we're going to help you with the revocable living trust, we want to make sure the funding happens properly, that you're actually going to accomplish what you're trying to accomplish with the trust. So I have great staff in my office for many purposes, including funding purposes. Our trust funding coordinator then would be the one primarily working with you. I'll be in the wings doing what I can to help, but primarily she would be helping. So we start our process off in that regard by giving you what we call an asset organizer, where you can just list your assets and some general information about them. And then we'll have a meeting that we call an asset game plan, where you and our trust fund coordinator will look at the information that you've put together, make sure it's complete, estimate some asset values, talk about some of the specifics of your estate, and then talk about how the assets ought to be aligned with the trust. And I'll go into more detail with that in just a minute. That information then will be taken by our trust fund coordinator and put into a program that we have in the office called Funding Pro, and that'll spit out a spreadsheet that we can use then in our work to make sure the assets get properly funded, that we don't drop the ball on different things. And then when we're done with the funding, that document serves as a record for us to know what your estate's comprised of, how it aligns with the planning that we've done. And then later on, when we're going back to make sure your funding is still up to date, we can use and update that spreadsheet as our tool for making sure we don't drop the ball. So I tell people the revocable living trust planning, in my view, for the people that do it, is probably the best kind of planning that we can do. But in order for it to really do its magic, it's really important that the assets stay aligned, that they be aligned initially with the trust and they stay aligned. And it's amazing how often that does not happen if we don't stay on top of that. So several years ago, we said we need to do a better job helping our clients accomplish that, so make sure their plan is going to work for them down the road. So we started a program we call the Peace of Mind Protector Program. It's a client care program where for the first year, you're automatically members as we help you get the funding in place and teach you about the trusts and get things set up well. But then going forward, we ask you to subscribe to the program and keep up your membership. And among other accomplishments that we have through this program, we keep your funding up to date. And we're going to update the asset spreadsheet that we've prepared initially so that if anything down the road happens, funding is up to speed. We don't have to go to the court to do what otherwise we can avoid. So we're going to, in the funding process, prepare a good list of assets, and then we're going to talk about what we're trying to accomplish. Yes, we want the assets either owned or directed to the trust, and generally, depending on the tax situation, it's going to be more or less important to maybe equalize assets between spouses. So we'll talk about what ought to be on husband's side of the ledger, what ought to be on wife's side of the ledger, what are the pros and cons in making those kind of adjustments. And then we'll just start going through the list of assets. So on our asset spreadsheet, the first thing we talk about are bank accounts. Many people, particularly a lot of our older clients, have automatic withdrawals and deposits into those accounts. And particularly if we're dealing with the Social Security, it's a kind of a pain to go back and make changes. So a lot of our clients say, Keith, do we have to change the ownership of these accounts to the trust, or could we leave it as is and somehow accomplish what we're trying to do? And the answer is, we can leave the account as is, and we can add what's called a POD, a payable on death provision, to a bank account, or if it's an investment account, a TOD, transfer on death. And if you pass away, automatically those assets will be transferred into your trust. That's great to avoid probate. It doesn't work so well with regard to avoiding a guardianship. Because if you, for instance, get in a car wreck and you're still here, but you're all beat up and you're just not able to handle your finances, we're going to have arrangements in place to accomplish that. And if we have assets not in your trust, the trust can't do anything. We may end up having to get a guardianship. Well, if we have assets that are owned by the trust, we don't need to go that route. So as part of our discussions in the asset game plan, we're going to see just how strongly you feel that we leave the ownership of accounts in your individual name with this POD or TOD designation. Because again, it'll deal fine with probate, but it's not going to work for guardianship. How important do you think that is? I think it's important, but it's your call. So we may or may not change ownership of the accounts, bank accounts, investment accounts, to your trust. Retirement accounts, 401ks, IRAs, and so on, we are not going to leave, or we are going to leave in your individual name. We're going to talk about the beneficiary designations. The ownership needs to stay in the wage earner's name in order to avoid Uncle Sam coming in and collecting a bunch of income tax too early. But the beneficiary designations can go different routes, and we'll want to spend some time talking about the pros and cons of different arrangements. One of the issues that we run into very often is people have a bunch of cars, and if we want to transfer them into the trusts, that's fine, but then each individual county wants to get some fees out of that. And if we've just paid our fees a month earlier, now we're going to go back and pay the same fees again the second time, that doesn't always sit so well with people. So we'll have a discussion how we're going to handle that. Would we leave the assets, would we leave the vehicles as is for now, but next time a registration comes due, would we change them into the trust? Would we leave them outside of the trust? As of the last legislative session, the Montana legislature allowed us to use the TOD, transfer on death provision, to vehicles. That was a new wrinkle. So now we can use either the POD or the TOD for bank accounts and investment accounts. We can use it for our homes, and we can use it for vehicles. So we'll see how you want to work that out with regard to your planning. Again, the transfer on death, the TOD provisions work just fine to avoid probate. They don't help to avoid a guardianship. So we'll just to see how important that is to you and what kind of a strategy you'd like to follow. With regard to your home, it's worth spending some time on how we want to handle that. We know we want those assets to be held in the name of the trust. Montana law says if someone passes away with individually owned real estate belonging to them, the only way to transfer that, if we don't have a TOD provision in place, is a probate. For non-real estate, for personal property, Montana law says as long as the value of all the personal property in the sole name of the person who's passed away does not exceed a total value of $50,000, we can avoid a probate. We can just use assets. So we'd want to have a discussion. Let's say we have an older vehicle and it's worth $15,000. Well, we could leave that as is, and that's not going to trigger a probate as long as the other assets in the sole name of this person altogether don't exceed $50,000. If you have a big collection of cars and they're worth $200,000 or $300,000, $400,000, then we're going to have to decide how important is it to you to avoid probate. How important is it to you to avoid guardianship? Because if we leave those assets as is, they're going to trigger a probate. If we put them into the name of the trust, we'll avoid probate and a guardianship. If we just do a TOD provision, we can avoid probate, but we can't avoid a guardianship. So those are the kind of issues that we're going to talk about with regard to the funding. Again, we want to make sure your plan is going to work. So for the first year, part of what you're paying us to do is help you make sure that happens. I've got a great staff to make that happen. And our suggestion is, why don't you stay in the program afterwards, because it's amazing how often asset ownership changes, things happen, and we don't always think of our planning, and pretty soon we've got our planning out of line with our asset ownership, and we're looking at more of a hassle for the family. We're looking at more expenses down the road. We're looking at lack of privacy that we could have avoided in the first place. So those are some initial comments with regard to funding. We'd be happy to talk about any more details. And of course, if you dive into our process as part of our asset game plan and the other meetings with our staff, we're going to talk about this in great detail. So I hope this has been informative for you, and look forward to seeing you.